Okay, so we're going to get started for the afternoon session. Just wanted to say that we have amazing participation from the ministry today, and that's always great to have. And so we'll start off this afternoon with Alan McCammon from the MOE.
Thanks, Ross. And on behalf of all of us at the ministry, thanks for all the hospitality here today. It's great to see everybody that we're on the phone with and writing to all the time. So I'll just check that it all looks good here. When I saw the agenda for today, I was wondering if there might be a bit of overlap, perhaps, with some of the presentations from earlier in the day, but I don't think there will be, so I won't have to think on my feet quite so much right now in terms of coming up with a presentation that has nothing to do with that. So I'm going to focus on that mostly. I'm going to add one thing to this presentation at the end if the timing is good. I have 30 minutes apparently, is that right? And that will be just to give you a little informal update on some of the things we're doing at the ministry that relate more broadly to compliance initiatives, or as I like to call them, remediation assurance issues. But we'll start with this. So, this presentation actually was given 2 years ago, I think, maybe even in the same place. But what I've done is I've put our new colorful slide backgrounds on everything. I subsequently found out that the practice guidelines themselves that you all operate under have had some subtle changes, so I updated that. But for the most part, the messages are the same, and of course, there'll be a number of people here today that weren't there 2 years ago, and hopefully there'll be some value here. And this presentation is really just a kind of a reminder for some stuff that I'm pretty sure you're aware of, but stuff that we consider quite important in terms of the work that you do. So, as you all know, to become an approved professional in BC, you have to qualify by virtue of both your educational and professional experience backgrounds in technical work, but also having knowledge of the regulatory regime in British Columbia for undertaking this kind of work. And the role of APs, of being able to bring recommendations directly to the ministry to support the issuance of legal instruments like certificates and approvals in principle and so forth is a big responsibility. You're largely doing everything that our staffing teams would have been doing over the years, and helping us collectively get a lot more done in this province, as our ministry teams have never really increased in size and probably won't. So, most of us here probably have become qualified to be here in the first place because of the technical education and experience that we've had. But as you have begun your practices in British Columbia, you have essentially become better and better qualified to understand what the laws are in BC about carrying out this kind of work. So there's really two major parts to what you do, and it's the technical and the regulatory. So again, this presentation is to provide some important reminders, a couple of excerpts from your practice guidelines to show where this crops up in an effort to continue our increasing focus on compliance and high-quality cleanups in BC. So this is just a snapshot of the really nice website that CSAP has on the link related to practice guidance. And you can actually pull up the entire document there in a single file, or you can pull up individual appendices, and they run the entire gamut of the remediation process for information on how to approach that work. The opening paragraph there just talks about the role of the AP and what the expectations are, and then the guidance goes into more detail. So I'm going to show a series of excerpts from the practice guidelines. These are the same ones that have been talked about a little earlier today. They're dated November 2010, and those are the current ones in effect right now. So for an approved professional, like many and most of you, the primary responsibility that you have is to determine if the work you're reviewing meets the requirement of the Act, regs, and protocols. And it's true that beyond the Environmental Management Act and the regulations under it, as well as the protocols under it, it's possible that there are other provincial or federal laws that may apply to the work that you're doing. So again, knowledge of that, awareness first of all, and then knowledge of how those provisions operate is an important piece of this. And yeah, that sets the stage for everything, because those are extremely broad terms to say that the work you're looking at needs to follow, a statute, a series of regs, protocols, and stuff. That it's easy to say it in one sentence like that, but it's a lot of work. So another section, just one step further along in these guidelines, relates to the issue of deviations from legal requirements. What's the duty of an approved professional if, in looking through work, you see that there's been an issue, something missing, something hasn't been done, or it hasn't been done correctly. Some of the examples that are given right there on the slide out of the practice guidelines, they highlight some of those important notification requirements that we have in BC to write to the ministry or write to a neighboring property owner regarding off-site migration likelihood or actuality. There's requirements, some of you who have seen approvals in principle, of which there are not quite as many as certificates, but if you see in there's some language in there around advising the ministry if there are changes to a remedial plan, things like that. There's the whole regulatory piece related to relocation of excess soils from a contaminated site to a receiving site. When is that required? Did the lead investigators and practitioners get the CSRA when they needed it? Issues to do with hazardous waste, there's a whole number of requirements entirely under that separate regulation that if it turns out the site had hazardous waste, then those types of things should be considered. Basically, the responsibility under the guidelines here is for the AP to bring any deviations to the attention of the client and then work, encourage and assist perhaps in advising the client how to remedy that, to catch up with some missing notifications or other things. Obviously, if you come face to face with missing items that are a little bit like water under the bridge, you can't really reverse history and get this covered off. It leaves you with a bit of a dilemma, but it should be pointed out, because the question of any implications arising from that kind of stuff is a question just for the ministry to grapple with. We remain the regulators making those kinds of decisions, even though APs are carrying out so much of the work that we would have normally done with our own teams. But making decisions, well, obviously final statutory decisions remains exclusively the domain of the ministry, so far. If you've been listening to Mike McFarlane over the last few months, you might think that could change in the future. And the issue of evaluating whether something's in compliance and whether there's a compliance or enforcement-related implication there also remains with the ministry. Through these types of guidelines, we are interested in being advised of any, and we would expect you to advise us of any departures from requirements. Ideally, have them corrected, fixed, and it comes in and it's figured out, but if not, we want to know about it. It helps us in many ways. We're just like CSAP when it comes to performance assessment, and unsatisfactory submissions and so forth, the emphasis is initially put on education and those kinds of steps, when we also have to ask ourselves as a regulator, does it make sense to come down hard on this kind of stuff, or is there something that's unclear about the law, that has had people miss these things? Is there something we can do? We're not, you do not see us each week, enforcing and taking and initiating, legal proceedings on these types of matters. We will learn a lot if we see a pattern developing where people are not realizing that a requirement applies and so forth. And I have a concrete example of that. One of the ones at the very bottom of this slide, I added that little reference to the waste discharge requirement in the Environmental Management Act. That is in Part 2 of the Act, which is precedes the part that you're all most familiar with, I assume, Part 4, Contaminated Site Remediation. Part 2 has a very simple prohibition on discharging waste in BC. You can't discharge waste in BC unless you hold an authorization for that, or there's a regulation that speaks to it, or you are ordered to do it, and any other number of potential accommodations for waste discharge. So yet you should have that question always running through your mind when you're dealing with material on a client's site that would be considered to be waste. And although there are not a lot of tests at the court level or before the Environmental Appeal Board on that waste test in the context of contaminated sites work, the general starting position that we use for reference is that if the quality of the soil is unsuitable or inapplicable to the actual land use on that site, that material could be considered a waste. That's a starting point. And then we go with there. Certainly we would encourage you, if you had questions about that as to whether a permit was necessary or an authorization, give us a ring when you're carrying out these projects in advance so you can build it into the work plan or not. Feel free to put hands up and ask questions if you'd like to on the fly here. So here's an appendix excerpt from the practice guidelines. It relates to APs conducting reviews of remediation plans. It really, I think what you're going to see in the next couple of slides is just hopefully a reinforcement of what I have just gone over. Hopefully it's consistent, but there's a section in those Appendix C guidance for that component of work by an approved professional that deals with management of wastes. So identifying the waste streams, does the remediation plan and the project identify them? Are they adequately characterized so that you can actually do a confident classification of material, soil, water, that may be pumped out or whatever? Disposal or management methods, and all the various types of things you would do in a remediation plan, because that's what this context is, but the things the author of that plan would do to consider the alternatives available in British Columbia and practically work out what the cost implications or the timing implications are for all those various options, and then choose the one that works best for the client and the one that will meet the requirements in BC. And then identify if there's any authorizations required, like the discharge permit we talked about and the CSRA that we talked about a little earlier on. Another excerpt from that same portion of the guidance, practice guidelines in BC for CSAP practitioners is third parties and consultation. So it asks the question about that very important notice of offsite migration. The second part there talks about the written agreement with offsite owners, for the purposes of additional investigation or carrying out remediation itself, and in particular in the case of risk-based proposals. There's again the reference in C on the screen there to regulatory requirements, and then broader public consultation, which It takes place in BC on sites from time to time, and it's not so much because we use an authority that we have to order that to happen or to require it somehow. It's just often because a community has become interested in that particular site. It's gotten some attention, perhaps in the media and so forth, and a number of us have experienced over the last little while going to public meetings to be a resource for the public. For the most part, proponents lead those public consultations, and we're there as a reference for everybody. But I diverge, and I also walk away from the mic. Appendix D of the guidance, practice guidelines, deals with review of confirmation of remediation reports. So that's in the context of certificate applications. And so I underline a couple things there. Notices of IR, commencement, completion. There's timing requirements on those. 10 days before or so, or 3 days before, 90 days after. Can't remember exactly, but you just look at those and do your best for your client on those. Number 9 is kind of funny there because I think you're unlikely to be advising on excavation off-site if you haven't already been in touch with the next door neighbor. Waste management, those words at the bottom were just other sections in Appendix D that related with those particular issues, and those are repeat. So I'll just take the last little bit of time I have here to describe a little. Actually, maybe I'll just, before I do, yes, Jim has a question. So
just a brief question on, it's not necessarily related to contaminated sites, investigation or remediation, but in particular with respect to waste discharge.
Yeah.
What's the feeling on drilling mud? We have actually had that come up on an investigation project in wildlands areas where it was requested that the use of drilling mud actually have a waste discharge permit associated with it.
Yeah, that question is part of a family of related questions. Some of the other examples we get, it's about introduction of material, into the subsurface, and whether that would constitute, I guess, a waste discharge, or just how that should be handled. Another one is the situation on remedial projects where there might be, an amendment to the groundwater system or something like that to assist with in situ remedial approaches and so forth. And it's a question we get from time to time. And I guess when you literally look at the way things are written, you have to just ask yourself if it meets the definition of a waste. I mean, that's where you start to assess that. That is, I haven't worked specifically with that question. Certainly, we've done it with some of the amendments to groundwater type cleanups and things like that. But any of my colleagues had that one come by their phones or emails? When we've been challenged with that kind of question, we've kind of gone back to bare bones and asked ourselves, is it the sort of thing that realistically could cause some sort of environmental impairment or problem there? And if so, would it be wise that there are some checks and balances and controls in place? That's kind of how we would attack it from the core issues that mean something here. Because the issue behind the waste discharge is that type of thing. What kind of limits should there be on the discharge of this waste? What kind of monitoring requirements or various other types of control things should be in place, and how should we write those down as a regulator and convey and impose those requirements to a party? But that must be a pretty common thing up there, and I don't know the answer to it. Nobody else wants to say anything either. So maybe what we could do is we could give that a little bit more thought, Jim, and maybe get back to you or the group perhaps, maybe through Catherine or something like that. Any other questions that relate to what I've presented so far? John?
Yeah, I have a comment. creating and issuing contaminated sites of legal influence. And then Appendix 1 of that procedure is a regulatory checklist. So, if you want to cover off all the bases, you could easily just go to that appendix and have a look, make sure you've thought about all those things.
Thanks, that's helpful, yeah. I think we're the checklist capital of the world. Next question. For now, we're going to get there soon. Cindy.
So with historical waste discharge, like a truckload from your site went somewhere and it was noted, no one knows where it went. They do know it carried contaminated sites. It was, 10 years ago. And it's been brought up during the AP review and it's been identified. Do we need to, are we under the obligation to come talk to MOE to sign off on that? Because there's no way we can track it. We can identify it in the summary site conditions, but do we need to speak to the ministry if we come up with that situation before we can sign off on our summary of site conditions?
Right, and how would the discussion have gone with your client, I guess, initially on that? I mean, so it's quite open-ended the way you described it there, and that leaves a lot hanging there. Clearly, we're not an agency that has any luxury of resources to do that kind of detective work. I think it's better that it's documented, that it's not washed away or anything like that. So, again, with roster recommended applications, the basic premise here is that the ministry is not typically doing substantive review on this thing. We're meant to be relying on, I think what we want to know is if the recommending AP, reviewing AP, has some significant concern about that. Ideally, you would see if you could follow up on something to see if it can be figured out where that went. Maybe there's some way to do it. And because at the end of the day, we're just wanting to try to ensure that hasn't caused another problem, right? That it has some significance to it. So whatever you can do. But if it honestly is just they drove off in the dark, and that was the way it probably is the way it happens, and it's probably the way it perhaps doesn't quite get documented, but that it could be boiled down to that. We're a little out of luck. And what's going to maybe happen is we're going to hear about it from another direction and completely unrelated to your application and all that happened there. We're going to get a complaint, from another part of town or another community or something like that down the road because they're seeing something seeping out of a pile of soil or who knows. And it'll be dealt with at that time. But honestly, if you have we have a situation of ignorance to that extent. We don't have crystal balls as the MOE staff, compared to APs. We all have the same useless crystal balls typically for that future prediction stuff. So I would not avoid it. I would see if there was any way to try to find out what happened. And you're welcome to phone and discuss it with somebody like myself or other members of the group. If you find yourself in those situations, we're just looking ultimately for the environmental protection. So I just would maybe mention now just a couple things about our slow and steady increase on increasing emphasis on our compliance work as a ministry. Some of you may have heard me say this before, but when I've spoken with people across Canada and some colleagues in the States, typically in the brownfield context that I work in, it's been really interesting to hear that there's not a lot of regulators that are particularly good at doing the back-end checking on files that they may have been quite heavily involved even in on the front end. Typically, the sites that are risk assessed and risk managed and maybe have a component of follow-up work to do that proponents commit to, and life goes forward. Checking out management systems, reporting, monitoring, that kind of thing. It seems that jurisdictions seem to be more capable and have the capacity and ability with their groups to do the front end, and that is establishing regimes and standards and ways of having sites dealt with within their borders. So we've recognized that, just like they recognize it, as a bit of a gap in our regime, and we have tried over the last few years to sort of develop a better approach to this. So some of the things that you see these days that are directly related to this is the whole issue of updating the templates for these instruments, because doing the follow-up work on requirements or so forth that are imposed in instruments is a lot easier if the language is clear in those as to what the requirement was in the first place. So when you look at some of the older instruments we've had, you can see right away that they're not very easy to interpret, and it makes it difficult both for the individual who has the responsibility to meet the requirement. It also makes it difficult for an agency like ours to evaluate whether those milestones have been met. So this continual improvement of the language of our instruments is a really big piece of this compliance work. Another big piece is those of us in the ministry work on a fairly daily basis with the back end to the electronic site registry. And we have added a series of powerful notations in there that relate to requirements that have been imposed in connection with, for instance, a certificate of compliance, or perhaps if we're exercising different kinds of authorities, like an order, or some of you may have heard of the independent remediation authority that allows a director to impose conditions in connection with remediation. 54.3D is the provision. When those conditions are imposed and we finally sign off instruments and documents, we add to the registry new notations now that indicate that requirements exist. And we attach due dates to all those notations. And we've developed a query system that allows us to go through the entire site registry of 16,000 some odd sites now, I guess, and bring up requirements that have passed due dates or that are approaching due dates. And then that allows us to quickly direct those to colleagues who are associated with those files. And from time to time, some of you may have already experienced that over the last little while, you or your clients might get phone calls or emails from us just to check on where is a certain report, or where is a certain AP statement, or something like that. So we never had that ability before, and so it's a combination of a number of things like that: the improved clarity of our documents, along with a tool to be able to essentially have a tickler system ourselves that just keeps reminding us once a month of how things are going and what's coming in and what isn't. Those all work together and allow us to do some of that checking. So, and we just feel overall that just improves the general quality of the remedial work that we get done in BC if we can, ensure that those typically those risk-based remedial solutions continue to be valid and operate okay. So that's all I wanted to add. So. Yeah, that's a good question. So Mike was just asking if there was a way that the public or yourselves and all collectively could access those requirements. And I believe that's our intention, to do that. I don't know, Vince, are they actually publicly visible yet? No, they're just...
Yeah, they
are they?
They would just have to do it would be the same as doing any kind of query through a site registry search.
Okay.
You'd have to do a detailed search, and it would
right. Yeah.
all that information because it comes up as a notation.
Okay, okay. And to maybe build on that, so it is possible to do it, but it's, it still remains a little bit behind our current processes for getting access to that registry and, cost implications and so forth. I think, again, to make reference to some of the messaging that Mike's been given, Mike McFarlane, our director, over the last little while, I think we're hoping in the not too distant future to have an even more accessible site registry, because not only would that be handy for you and your clients, there's an advantage too for the general public to just be aware of those kinds of things and maybe have an opportunity to look into it too, because that just gives us even more ears and eyes out there to ensure that all the sites stay on track. So, John?
If you're done with that part, I have the answer to the question about the oil and gas drilling muds.
Oh, the answer. Fantastic.
And the answer is there are many regulations under the Environmental Management Act, and one of them is called the Oil and Gas Waste Regulation. And it's got a section 7 sub 1 that authorizes the discharge of produced water and what they call recovered fluids. If that's consistent with the Oil and Gas Activities Act, OGA. So there is a regulation that authorizes that discharge under the Environmental Management Act.
Sorry, I didn't know that your question was about oil and gas drilling mud, was it? No, I didn't think so. Yeah, there's a lot of other regulations that the OGC will. Yeah, sorry, I didn't. There was something else to add, but I don't need to.
So we have the answer in the context of that type of work, right? Yeah. So it sounds like it's a discussion in progress. So I'll sign off. Thanks for the attention.